Committee proceedings are resumed. Please be seated. Honourable Minister, I believe we're still on clause 2.
Madam Speaker,
Member from Northside.
I guess I'm partly satisfied enough that the government will take whatever action is needed to address the matter that I raised. So in light of that assurance given by the Attorney General, I'll simply just withdraw the amendment at this time. So we can move on.
The question is that the amendment moved by the member of Northside as it related to clause 2 be withdrawn. All those in favour, please say aye.
Aye.
Against, no. The ayes have it. The amendment has been duly withdrawn.
Clause 3, appointment of registrar of non-profit organizations.
The question is that clause 2 stand part of the bill? All those in favour, please say aye.
Aye.
Against, no. The ayes have it. Clause 2 now stand part of the bill.
Clause 3, appointment of registrar of non-profit organizations. Clause 4, functions of the registrar. Clause 5, establishment of a register of non-profit organizations. Clause 6, registration application. Clause 7, consideration of application and registration factors. Clause 8, cancellation of registration. Clause 9, appeal against cancellation or refusal of registration. Clause 10, inquiries into condition and management of non-profit organizations. Clause 11, false or misleading information or withholding information requested by the Attorney General. Clause 12, keeping books of accounts.
The question is that clauses 3 through 12 stand part of the bill. All those in favour, please say aye.
Aye.
Against, no. The ayes have it. Clauses 3 through 12 now stand part of the bill.
Clause 13, examination of accounts.
Recognize the Honourable Minister for amendments.
Thank you very much, Madam Chair. Madam Chair, in accordance with the provisions of Standing Order 52.1 and 2, I, the Minister for Commerce, Financial Services, Commerce and Environment, give notice to move the following amendment to the Non-Profit Organizations Bill 2016, that the bill be amended in clause 13.2a by inserting after the word, quote, accountant, the words, quote, who, comma, neither for profit nor reward, comma, undertakes to perform the review.
The amendment has been duly moved. Does the Honourable Minister wish to speak to it?
Madam Chair, I can just briefly indicate that this was an amendment which resulted from a need to avoid a conflict with the accountant's law. And it indicates that the person providing the accounting or audit services could be providing it for free, effectively providing those services for free.
The question is that the amendment stand part of the clause. All those in favour, please say aye.
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 Those against, no. The ayes have it. The amendment stands part of the clause. The question now is that the clause as amended stand part of the bill. All those in favour, please say aye.
Aye.
Against, no. The ayes have it. Clause 13 as amended now stand part of the bill.
Clause 14, appeals against an examination request.
Honourable Minister, there is an amendment to clause 14.
Yes, Madam Chair, thank you. Madam Chair, in accordance with the provisions of Standing Order 52.1 and 2, I move that the bill be amended in clause 14 by deleting the words, quote, in accordance with section 13, subsection 2 and 3, close quote, and substituting the words, quote, in accordance with section 13.3, close quote.
The amendment has been duly moved. Does the minister wish to speak further to it?
I think it's self-evident, Madam Chair, so.
The question is that amendment stands part of the clause. All those in favor, please say aye.
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 Against, no. The ayes have it. Clause 14 as amended stands part of the clause. The question is now that clause 14 as amended stand part of the bill. All those in favor, please say aye.
Aye.
Against, no. The ayes have it. Clause 14 as amended now stand part of the bill.
Clause 15, due to prepare annual returns. Clause 16, failure to comply with law. Clause 17, imposition of administrative penalties. Clause 18, procedure to be followed by the registrar. Clause 19, appeal against administrative penalty. Clause 20, limitation period.
Question is that clauses 15 through 20 stand part of the bill. All those in favor, please say aye.
Aye.
Against, no. The ayes have it. Clause 15 through 20 now stand part of the bill.
Clause 21, exemption of organizations.
I recognize the fourth elected member for Bodtown for an amendment.
Thank you, Madam Chair. I'd like to move an amendment to that clause, which reads as follows, that the bill be amended in clause 21 by deleting subclause 2C and substituting the following. C, existing service clubs, churches, and educational associations and clubs.
The amendment has been duly moved. Does the honourable member wish to speak to his proposed amendment to clause 21?
Briefly, Madam Chair, it's just I don't understand the rationale behind having the need to exempt, but if there is an exemption clause in the bill, what I would like to see is that it be tightened up so that it's not completely open. And perhaps this wording will allow existing charities and service clubs who are considered to be in good standing and operating above board to be included in the bill, rather than have to consider each one on its own merit individually.
Honourable Minister.
Madam Chair, thank you. Madam Chair, it's interesting that the member, certainly during his debate, commented on the existing 21(2)(c), as which reads any other entity that Cabinet may by order exempt. And in a full context, 2 says this law does not apply to any other entity. C, any other entity that the Cabinet may by order exempt. The member commented that was, in his view, a dangerous provision. But while his proposed amendment seeks to delete that provision, and it's not something that causes a tremendous response or reaction from me, the proposed replacement is effectively what some people would call driving a horse and coaches through the bill itself, in that it would seek to exempt a significant group of nonprofit organizations, which the bill seeks to effectively regulate. So if we were to remove existing service clubs, churches, and educational associations and clubs, that could be a very, very significant percentage of the bodies that this bill seeks to cover, and it would destroy the efficacy and the purpose of the bill. Now, Madam Chair, I will say that I would love not to be in a position where we have to create any kind of additional regulation anywhere. In fact, we'd love to be in a position where we can reduce lots of regulation. But this, for all the reasons that were explained during the debate, both myself as well as very, very well put by the Honorable Attorney General, this is a bill which needs to encompass the very organizations that the member seeks to exclude from the bill at this point by this proposed amendment. And unfortunately, it's not one that we can agree to. Although I would dearly love to be in a position to do that, but I don't think we just can't.
Does any other member wish to speak? As the,
Just to say,
sorry, Honorable G, but I have no line of sight to where you're sitting, sir, so I can't see when you try to make an intervention.
some of this is a
Go ahead.
Oh, you can't see me. Oh, that's the premier. Yeah, is that Kessler? Sorry, Madam Chair. Just to say that I certainly concur with the observation of the Honourable Minister. First of all, I think it's unnecessary to remove the ability of Cabinet to exempt charities or NGOs. I mentioned earlier on when we did the second reading that we might very well have instances where, natural disasters and all of that, and need Cabinet to be able to waive some of the requirements of some of these NGOs to allow quick relief in. That's an example that comes to mind immediately. But in addition to that, the amendment proposed by him would mean that we really don't need a law, because what he's proposing here is really the entire menu of what we're trying to regulate. Yeah, so I'm not so sure why we would need a law and so on. So I fortunately I can't support the observation or the suggestion by the honourable member.
Madam Chair, just to clarify, because what I'm trying to
Honourable fourth elected member from Bordentown.
what I'm trying to get at is that leaving it wide open, I still view as dangerous. So, I'd prefer to see some verbiage in there that would tighten it up so that there are circumstances under which they would be exempted, rather than just leaving it completely wide open and Cabinet can just exempt whoever they wish. So that's what I was attempting to do. Any other wording would be acceptable to me as well, if it put some restraint on it, some conditions on it. So the Honorable Attorney General just mentioned, natural disasters and so forth, emergency situations. Maybe we could use that wording, but I'm just not comfortable with leaving it wide open.
Honourable Minister, did you have a response, or can I put the question?
Madam Chair, I hear the member's comment and suggestion, but it seems to me that he is proposing removing a section and replacing it with a complete exemption, as the Honourable Attorney General has noted, and as I noted earlier, from just about every organization. So I think that's far from anything that you could call tightening up. So I don't think it's anything that has been stated could change my view on it.
Madam Chair,
Honourable Attorney General.
just to say, what I could undertake to do is, when we're crafting the regulations, we could probably put some language in there to provide some guidelines as to the circumstances under which exemption would be considered, so that there's some sort of parameters that would explain the exemptions.
Honourable fourth elected member from Bordentown.
Thank you, Madam Chair. Yeah, that is what I'm trying to get at, some parameters. And which is why I use the word existing, because I'm assuming that existing organizations have been vetted and, are acceptable, but not going forward, but existing. But I'm happy with what the Honourable Attorney General is suggesting.
Okay. Does that mean that the Honourable fourth elected member wishes to withdraw the amendment, or?
Yes, Madam Chair, I'm happy to withdraw the proposed amendment.
The question is that the proposed amendment to clause 21 be herewith withdrawn. All those in favor, please say aye.
Aye.
Against, no. The ayes have it. The proposed amendment to clause 21 is hereby withdrawn. The question is that clause 21 stand part of the bill. All those in favor, please say aye.
Aye.
Against, no. The ayes have it. Clause 21 now stand part of the bill.
Clause 22, regulations. Clause 23, expenses. Clause 24, transitional provisions.
Question is that clauses 22 through 24 stand part of the bill. All those in favor, please say aye.
Aye.
Against, no. The ayes have it. Clauses 22 to 24 now stand part of the bill.
A bill for a law to provide for the regulations of nonprofit organizations and for incidental and connected purposes.
The question is that the title stand part of the bill. All those in favor, please say aye.
Aye.
Against, no. The ayes have it. The title now stand part of the bill.
The Customs Amendment Bill 2016, Clause 1, short title.
The question is that clause 1 stand part of the bill. All those in favor, please say aye.
Aye.
Against, no. The ayes have it. Clause 1 now stand part of the bill.
Clause 2, amendment of Section 2 of the Customs Law 2012 revision, definitions.
I recognize the Honourable Minister for Finance for an amendment to clause 2.
Thank you, Madam Chair. Madam Chair, in accordance with Standing Order 52, subsections 1 and 2, I propose that the bill be amended as follows. In Clause 2, the definition of the term inter-island be amended by deleting the words journey is and substituting the word journey, and by deleting the words or is and substituting the words or it is. To read, Madam Chair, inter-island in relation to a ship or aircraft means that it is to journey from one island in the jurisdiction to another island in the jurisdiction, or it is about to start a journey. Thank you, Madam Chair.
The amendment has been duly moved. Does any member wish to speak to the amendment? Member from Easton.
Madam Chair, I'm trying to get my, Madam Chair, I wonder if this is to satisfy the provision that I questioned during the debate about the rotation number that is currently used between the islands. And because, as I recall, that was at a different provision in the law. And I'm trying to find it here. But, oh, here. So I'm wondering if that will address that section of it.
Member from Easton, you're finished with your...
Yes.
Oh, thank you. Honourable Minister for Finance.
Thank you, Madam Chair. If I may have a moment to confer with my staff.
Most certainly.
And I can't find it right now. Yes, so much people.
Madam Chair, I'm advised that the rotation number is a number that is given by the Port Authority for search and rescue purposes, and they then provide that number to the customs, but it is not something that the customs actually requires. That's what I'm advised, Madam Chair.
Honorable member from Easton.
Mr. Chair, Madam Chair, I'm a little surprised that's news to me. I didn't know that was.
Madam
I
Chair,
didn't know that was the origin of that Yeah. No man, that's
Member from Easton, you're seeking a clarification or confirmation?
yes, 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 Miss Madam Chair. I've always known the rotation number to be when we, and I have done this on many occasions long before coming to this parliament, when we want to go to Cayman Brac from Grand Cayman or Little Cayman, and maybe what happens is that upon starting that journey by boat, we call the Port Authority and explain where we're going, and they give you a number, and then upon the arrival in Cayman Brac or Little Cayman, you give the customs there and immigration there that number. And of course, that means you have arrived, and they use that for their own security service purposes, such as seeing if that's where you really went. So I don't know if this is a different thing that the minister's talking about.
Honorable Minister for Finance.
Madam Chair, I'm asking for clarification on the matter because I myself have no experience with getting rotation numbers. So I'm asking for clarification as to whether it's customs or the Port Authority that issues the number.
Yes, Minister.
So, Madam Chair, in the interest of time, perhaps we could move on to Clause 3 and then resolve Clause 2 once we've confirmed that.
Subject, I'm sure, to the normal reservation by members that if it's a subsequential impact on it, that they would wish to recommit it. Madam Clerk.
Clause 3, insertion of section 12A, advanced documentation for inward ships and aircraft.
Honorable Minister, I believe you have amendment to Clause 3.
Yes, Madam Chair. Madam Chair, in accordance with Standing Orders 52, subsection 1 and 2, I propose the following amendment to the bill, that in Clause 3, under section 12A2, that we insert after the word ends, the words, or in the case of a ship that has been outside the jurisdiction for less than 48 hours, at least 8 hours before the inward journey ends.
The amendment has been duly moved. Does the Honorable Minister wish to speak further to the amendment?
No, thank you, Madam Chair.
Does any other member wish to speak? The member from Easton?
Madam Chair, here is one again that I spoke of, that I wonder how it's going to affect the provisions in the law for recreational, I believe it is, and fishing, because the majority of the times they are not out for 48 hours. It's a 2-3 hour journey in most cases, and then they fish for 5-6 hours, and then they're on their way back. So in most instances, it's not a 48-hour journey. And this is, by insert after the words ends, the words, or in the case of a ship that has been outside the jurisdiction for less than 48 hours, at least 8 hours before the inward journey ends. So you're clear to go out. You can't provide that to come back in. Now, Madam Chair, what, and the member from West Bay and I have been working on this for quite some time. What we are trying to do is to get in the situation where we register the boats with immigration and customs, and when we are going on these trips, we notify them with all the particulars, and then they would have that boat registry there, and we would just tell them how many souls are on board and the destination and the time of return. Now, I don't know if this covers that, if this provision would cover that under those conditions, because it would be within 48 hours. I don't know.
Honourable Minister.
Madam Chair, I would have to confer with the Collector of Customs who's stepped out of the chamber to confirm the other issue. So I beg your indulgence.
Perhaps, Minister, we can, subject to the same reservations, again, then move on to 4, 5, and 6.
Yes, Madam Chair.
Clause 4, amendment of section 14, master or commander to make report. Clause 5, insertion of section 32A, advanced documentation for outward and inter-island ships and aircraft. Clause 6, insertion of section 74A and 74B, electronic notices by customs, evidentiary provisions.
The question is that clauses 4 through 6 stand part of the bill. All those in favor, please say aye. Those against, oh, sorry, Member Meeson, you were trying to catch my eye.
Thank you, Madam Chair. Madam Chair, that is precisely where I brought this matter up. Under 6, I think it is. I think it was 6.
Oh, because we were at clause 3.
No. Madam Chair, it was clause. Want you reading all those clauses then, Madam Chair? And I do apologize, but
We did clause 1, which we've taken a vote on. Clause 2 and clause 3 is held in abeyance, subject to further clarification from the technical staff of the Honourable Minister. And we were moving on to put the question on clauses 4, 5, and 6.
well, under 5 as well, an outward ship or aircraft that is to carry outward passengers or exported goods, which passengers or goods have not been cleared, or an inter-island ship or aircraft carrying passengers or goods. Under 5.5, where it's in certain 32A, 1B.
Did you have anything under clause 4, honorable member?
Oh, you only went to 4?
No, but I put 4 and 5. You're now making an intervention.
Under 5, yes.
So can I put in clause 4? I'm asking are there any questions under 4? Or can I put that?
Not that I recall, Madam Chair.
If there's no debate or further questions, I put the question that clause 4 stand part of the bill. All those in favor, please say aye.
Aye.
Against, no. The ayes have it. Clause 4 now stand part of the bill. Honorable Minister, it appears that there may be interventions with clauses 5 and 6. If you could put them at this time.
Madam Chair, I apologize. I'll have to find those. Thank you.
Madam Chair.
Member from Easton.
Thank you. Madam Chair, and for the benefit of the minister, all I'm trying to do here is to avoid a routine thing that we did before, to avoid the interpretation of that being all twisted up and become a convoluted thing. Because I don't believe a lot of people knows about that provision that has been in place for a very long time, long before me, where they would give this rotation number, we call it, for inter-island, yeah. And it is such a useful tool to have, whether it's, I don't know whether it's in the regulations or not, but somewhere somebody was very creative with it, and it's a very useful tool especially when you go into fishing tournaments in Cayman Brac. You know, you call in the number, and then when you get Cayman Brac, you call it in the Port Authority, which the custom uses as well, I believe, custom and immigration, that, you know, we have traveled to Cayman Brac. Mind you, it's not I don't know if it's a border control, so to speak, with, you know, but certainly it gives them the opportunity to know who's coming into Cayman Brac, I believe, and it further gives the Port Authority that opportunity to know that, and customs to know that a boat leaving in Cayman, they really did not go mid-seas to do anything illegal or something of that nature. Because if you're required to call in when you get to Cayman Brac, they can figure the amount of time you utilize between the two islands. And I think it's a tool they're using for control or tracking of citizens, so to speak. I don't know.
Honorable Deputy Premier.
Thank you. Madam Chair, I believe that the question that the member from East End is asking is one that I would ask as well, is how does this law affect a pleasure boat or a fishing boat that is going to Cayman Brac, Little Cayman, to enjoy a weekend or to fish in a tournament? Will this law affect them, and how will it change what they do today? My understanding is that the rotation number is issued by customs at the seaport. I don't know. That's what I always understood.
Madam Speaker,
Member from Easton.
for the purposes of edification and stuff, it's customs that do it in Cayman Brac, I think, because we call there and say rotation number so and so, so and so, which Grand Cayman has already called and told them about. You see? Now, I don't know how this is going to affect them by talking about the journeys between there that you got provide other information in this regard. I don't know if that's going to affect those. Because if it is, then it's going to not be as an efficient, because you can go out in the middle of the night, 12 o'clock at night, to go to Cayman Brac. And then, and they got control over you, so to speak. Right. Right.
Second, like the member from Georgia, did you have an intervention?
No, ma'am.
Honorable Minister for Finance.
Thank you, Madam Chair. Madam Chair, I apologize for the interruptions, but I don't own as much as a paddle boat, so I am lost with these things. Madam Chair, going back to clause 2, clause 3. Clause 2, Madam Chair, with respect to the rotation number, I think that's what we're waiting on there. It has been confirmed that the rotation number is issued by the Customs Department. However, sometimes people will leave the harbor or wherever they're docked, go out to sea, and then remember that they needed to get this rotation number, contact the Port Authority. The Port Authority will then contact Customs, get the number, and then give it to the boat. So that's what happens there. But the number officially is given by the Customs Department. So that's clarified. Madam Speaker, Madam Chair, with respect to clause 3, Madam Chair, I would like to propose an amendment to the 8 hours, the word 8 that we've just added there in clause 12A2, so that it would read, Madam Chair, clause 12A2, it would read, a master shall give or cause the giving of the documents at least 48 hours before the inward journey ends, or in the case of a ship that has been outside the jurisdiction for less than 48 hours, at least 4 hours before the inward journey ends.
The notice requirement has been waived, and the amendment to the amendment has been duly moved. Does the Honorable Minister wish to speak to this amendment?
No, thanks, Madam Chair. Actually, yes, thank you, Madam Chair. Madam Chair, we introduced the amendment previously because the member from East End thought that the 48 hours was too much, so we introduced the amendment to less than 48 hours. And then we've discovered in discussion with the experienced voters that if they're going to one of the banks that are closer, I don't know the names. I have only been fishing twice in the last 15 years, so I won't pretend to know which bank they're talking about.
12.
So, Madam Chair, it is reasonable to believe that 4 hours would be adequate, and therefore we are reducing it from 8 hours before the inward journey ends to 4 hours before the inward journey ends, and that's as much as I can add to it, Madam Chair.
Member from Eastern. Are you holding the mic?
No. I'm trying to. Madam Speaker, the minister need help me now too. The Minister for Financial Services. I don't understand that though. If Madam Speaker, I think for the benefit of us all, we need to understand what we do. We go this evening, today, to the Customs and Immigration down at the Port Authority, and we make an exit plan. The exit with the passports and stuff. We fill all that out, and they stamp it that you're exiting the country. We're leaving tomorrow morning, 3 o'clock, 4 o'clock. We go to Pickle Bank, which takes 3-4 hours. Anyway, forget about that for a minute. We're back by 6 o'clock in the evening. We're not gone for 48 yet. We notify them when we reach back to the channel. Am I right, Minister? Or thereabouts? That we're coming in. And they meet us at wherever we're docking up, or they may say, take it to Georgetown. I don't understand how we're going to get this to them 4 hours before.
Madam Chair, if I may add, Madam Chair.
Honorable Minister.
The law or the bill says in 12(1)(a) that the master or commander of an inward ship or aircraft shall give customs the following documents electronically or cause them to be so given. Madam Chair, the master himself on the vessel does not have to give the notice of arrival. It can be, he can cause someone else to do so before they arrive, and therefore would be in compliance with the 4-hour notice period that the bill is now proposing. That's the way it's been explained to me, Madam Chair.
There's a question from the Minister of Works, Honorable Minister of Finance.
Sorry, sir.
Honorable Deputy Premier.
Here's my, Madam Chair, here's my thought. As I read the bill and thought the spirit of the bill was for, cruise vessel, a cargo vessel, an airliner coming to the Cayman Islands. The conversation that we're having is about a yacht, about a fishing boat, about something that people do for pleasure and charter, and small vessels. What you just read there, in my mind and in spirit, identifies the commercial aspect of this. And the questions that have come from both myself and the member from East End really talk about what we do here for sport fishing and what we do for charter. So maybe you could define if that is actually the spirit of the bill, or is this supposed to be all-encompassing for the fishing boats that go out and the people that do this for recreational value?
Honorable Minister of Finance.
Madam Chair, if I may just confer one last time, I'm of the belief that it is for just commercial aspects, where boaters may go out and meet someone on the high seas and purchase fish and then return, but I will confirm that.
Madam Chair,
Member from Easton.
just to say,
Can you just maybe wait till he finish consulting so that he can properly respond to you?
Madam Chair, I've been advised that if we try to differentiate between commercial and pleasure, it creates a loophole, and with the loophole, it may be abused. So that is the reason you don't know if it is commercial or pleasure unless there's a declaration. The declaration and the manifest has been given to the customs. So I understand what the members are saying, but I have to follow on the guidance of those who are responsible for doing the job. Without the declaration and the manifest, there's a loophole, and you don't know whether it's commercial or leisure. So with that, Madam Chair, I can't add any more.
Madam Chair,
Member from Easton.
and I'm trying, Madam Chair, I don't want to take anything away from the custom control this border. I want that straight. But we do a declaration. We declare that we're going for fishing, pleasure fishing, I think we put on it, something like that, to Pickle Bank or to 60 Mile Bank. We're outside the jurisdiction. We're going outside the jurisdiction. So immediately, we have left the country. That's why they'd have to stamp your passport. Where my concern is that this says, in the case of a ship that has been outside the jurisdiction for less than 48 hours. I'm outside the jurisdiction, and on 12, the master or commander of an inward ship. So anytime a ship departs, there must be a master named, whether it's a 40-foot cruise, sport fisherman, or one of the little 27-footers, you must name the master. Now, therein lies where it's getting a little grayish, because the custom officer is going to say, when you're a master, you can't leave the country without naming it. You're going to make a declaration, and you're carrying passengers, because there's only one master and all the others are passengers or crew. Now he's going to say you're going to be left, you're leaving for less than 48 hours, so 4 hours before you come back, you need to notify me. That's basically what it says. By electronic means.
Madam Chair, if I may just point out.
Honourable Minister of Finance.
Thank you, Madam Chair. Madam Chair, it says that the master of an inward ship or aircraft shall give or cause them to be so given. So it implies right there that the master may have someone else do so on his behalf or cause them to be so given.
I'll take one more intervention and then I'll put the question. Member from Easton.
Madam Chair, I understand we can go from here out there and fish, I wouldn't say less than 8 hours, because it takes 2.5, 3 hours to go. Oh, you can go 60 and do that, but you can go pickle 3.5 hours, go. It don't make sense for you to fish less than 6, 8 hours and then leave, and then you got another 3, 4 hours. How much is that? 8 and 6 is 14 hours, 12, 14 hours. Madam Chair, I guess we all carry sat phones. We'll just have call before we leave out there. And that's 3 hours, I guess. All right, I guess so.
Are there any more questions on 5 or 6? Otherwise, I'm going to put them together. The question is that clause 3, 5, and 6 stand part of the bill. All those in favor, please say aye.
Aye.
Against, no. The ayes have it. Clause 3, 5, and 6 also stand part of the bill.
A bill for a law to amend the Customs Law 2012 revision to provide for requirements for inward and outward documentation for ships and aircrafts and to provide for incidental and connected matters.
The question is that the title stand part of the bill. All those in favor, please say aye.
Aye.
Against, no. The ayes have it. The title now stand part of the bill.
The Proliferation, Financing, Prohibition Amendment Bill 2016. Short 1, Clause 1, short titling commencement. Clause 2, Amendment of the Proliferation, Financing, Prohibition Law 2014 revision. Clause 3, Amendment of Section 2, Interpretation. Clause 4, Insertion of Part 1A. Security Council measures generally. Clause 5, Amendment of Section 5, Conditions for giving a direction. Clause 6, Amendment of Section 6, Requirement imposed by the Monetary Authority. Clause 7, Amendment of Section 7, Customer due diligence. Clause 8, Amendment of Section 8, Ongoing monitoring. Clause 9, Amendment of Section 9, Systematic reporting. Clause 10, Amendment of Section 10, Restricting or ceasing business. Clause 11, Amendment of Section 14, Power to require information or documents. Clause 12, Insertion of new section, Application of the Proceeds of Crime Law 2014 revision. Clause 13, Amendment of Section 28, Report to the Legislative Assembly. Clause 14, Repeal of Section 32, Exercise of powers under this law. The Proceeds of Crime Law 2014 revision. The Money Laundering Regulations 2013 revision. The Terrorism Law 2011 revision. And the Terrorism United Nations Measures Overseas Territories Order 2001. Clause 15, Repeal of Section 37 and substitution regulations.
The question is that clauses 1 through 15 stand part of the bill. All those in favor, please say aye.
Aye.
Against, no. The ayes have it. Clauses 1 through 15 now stand part of the bill.
A bill for a law to amend the Proliferation Financing Prohibition Law 2014 revision in order to enable its compliance with the international standards and for incidental and connected purposes.
The question is that the title stand part of the bill. All those in favor, please say aye.
Aye.
Against, no. The ayes have it. The title now stand part of the bill.
The Terrorism Amendment Bill 2016, Clause 1, short title. Clause 2, Amendment of Section 2 of the Terrorism Law 2015 revision, definitions. Clause 3, insertion of new section, Governor's power to delegate. Clause 4, Amendment of Section 3, terrorism. Clause 5, repeal of Section 16 and substitution, inciting terrorism overseas. Clause 6, repeal of Section 18 and substitution, terrorism property. Terrorist property. Clause 7, repeal of Section 19 and substitution, soliciting terrorist property. Clause 8, repeal of Section 20 and substitution, use and possession. Clause 9, amendment of Section 21, arranging for property to be used for terrorist purposes. Clause 10, repeal of Section 43, terrorist definition. Clause 11, amendment of Schedule 4A, freezing of funds, etc., of designated persons. Clause 12, savings and transitional provisions.
Question is that clauses 1 through 12 stand part of the bill. All those in favor, please say aye.
Aye.
Against, no. The ayes have it. Clauses 1 through 12 now stand part of the bill.
A bill for a law to amend the Terrorism Law 2015 revision in order to enable its compliance with international standards and for incidental and connected purposes.
The question is that the title stand part of the bill. All those in favor, please say aye.
Aye.
Against, no. The ayes have it. The title now stand part of the bill.
The Judicature Amendment Bill 2016, Clause 1, short title. Clause 2, Amendment of Section 16 of the Judicature Law 2013 revision, number of jurors in criminal cases.
The question is that clauses 1 and 2 stand part of the bill. All those in favor, please say aye.
Aye.
Against, no. The ayes have it. Clause 1 and 2 now stand part of the bill.
A bill for a law to amend the Judicature Law 2013 revision to clarify the numbers of persons needed to properly constitute a jury in a criminal trial for money laundering offenses.
The question is that the title now stand part of the bill. All those in favor, please say aye.
Aye.
Against, no. The ayes have it. The title now stand part of the bill.
The Criminal Procedure Code Amendment Bill 2016, Clause 1, short title. Clause 2, repeal and substitution of Section 18 of the Criminal Procedure Code 2014 revision, service of summons. Clause 3, insertion of Section 18A of the Criminal Procedure Code 2014. New clause, service of witness summonses on designated public officers by electronic means. New clause 18A.
The question is that clause 1 and 2 stand part of the bill. All those in favor, please say aye.
Aye.
Against, no. The ayes have it. Clauses 1 and 2 stand part of the bill. I put the question at clause 3 stand part of the bill. All those in favor, please say aye.
Aye.
Those against, no. The ayes have it. Clause 3 stands part of the bill.
A bill for a law to amend the Criminal Procedure Code 2014 revision to authorize persons other than the police, such as bailiffs and other designated persons, to serve summonses, to provide for service of witness summonses by electronic means to designated public officers and for incidental and connected purposes.
The question is that the titles stand part of the bill. All those in favor, please say aye.
Aye.
Against, no. The ayes have it. The title now stand part of the bill.
The Penal Code Amendment Bill 2016, Clause 1, short title. Clause 2, repeal and substitution of Section 30 of the Penal Code 2013 revision, imprisonment in lieu of fine. Clause 3, savings and transitional provisions.
The question is that clauses 1 through 3 stand part of the bill. All those in favor, please say aye.
Aye.
Against, no. The ayes have it. Clauses 1 through 3 now stands part of the bill.
A bill for a law to amend the Penal Code 2013 revision to provide for a new graduated scale of increased maximum terms of imprisonment in relation to the default of payment of costs, compensation, or fines ordered by a court in criminal trials and for incidental and connected purposes.
The question is that the title stand part of the bill. All those in favor, please say aye.
Aye.
Against, no. The ayes have it. The title now stand part of the bill.
The Police Amendment Bill 2016, Clause 1, short title.
The question is that clause 1 stand part of the bill. All those in favor, please say aye.
Aye.
Against, no. The ayes have it. Clause 1 now stand part of the bill.
Clause 2, amendment of Section 146 of the Police Law 2014 revision regulations.
Recognize the Honorable Attorney General for an amendment.
Thank you, Madam Chair. Madam Chair, in accordance with the provision of Standing Order 52.1 and 2, I, the Honorable Second Ex Officio Member, move the following amendment to the Police Amendment Bill 2016. That the bill be amended by deleting Clause 2 and substituting the following clause. 2. The Police Law 2014 revision is amended in Section 146 as follows. A. By renumbering Section 146 as Section 146.1, and B. By inserting after subsection 1 the following subsection. Numeral 2. Further to subsection 1, the Cabinet may make regulations for the provision of information to another law enforcement or regulatory agency, whether local or international, which, notwithstanding the provisions of any other law, shall provide for the conduct of or provision of assistance with a criminal investigation as may be required for compliance with international standards relating to the prevention of criminal activity, including money laundering, terrorist financing, and proliferation financing.
The amendment has been duly moved. Does the honorable member or any other member wish to speak to it? If not, the question is that the amendment stand part of the clause. All those in favor, please say aye.
Aye.
Against, no. The ayes have it. The amendment stands part of the clause. The question is that the clause as amended now stand part of the bill. All those in favor, please say aye.
Aye.
Against, no. The ayes have it. Clause 2 as amended now stand part of the bill.
A bill for a law to amend the police law 2014 revision to make provision for regulations to be made to permit the sharing of information with other law enforcement or regulatory agencies as required for compliance with international standards relating to the prevention of money laundering, terrorist financing, and proliferation financing, and for incidental and connected purposes.
The question is that the title stand part of the bill. All those in favor, please say aye.
Aye.
Against, no. The ayes have it. The title now stand part of the bill.
The Proceeds of Crime Amendment, Number 2 Bill 2016, Clause 1, short title. Clause 2, Amendment of Section.
The question is that clause 1 stand part of the bill. All those in favor, please say aye.
Aye.
Against, no. The ayes have it. Clause 1 now stand part of the bill.
Clause 2, Amendment of Section 2 of the Proceeds of Crime 2016 revision, Crimes Law 2016 revision, interpretation.
Honorable Attorney General, there's an amendment to clause 2.
Thank you, Madam Chair. Madam Chair, in accordance with the provisions of Standing Order 52.1 and 2, I, the Honorable Second Ex Officio Member, move the following amendments to the Proceeds of Crime Amendment Number 2 Bill 2016. That the bill be amended as follows. A. In Clause 2 by deleting paragraph A, and B. By inserting after Clause 3 the following clause. 3A. The principal law is amended in Section 5.1H by deleting the words with anti-money laundering and counter-terrorism measures for designated non-financial businesses and professions and substituting the words with regulations made under Section 145 in relation to persons conducting relevant financial business who are not otherwise subject to such monitoring by the Monetary Authority.
The amendment has been duly moved. Does any member wish to speak to the amendment? If not, the question is that the amendment stand part of the clause. All those in favor, please say aye.
Aye.
Against, no. The ayes have it. The amendment stands part of the clause. The question is now that clause 2 is amended stand part of the bill. All those in favor, please say aye.
Aye.
Against, no. The ayes have it. Clause 2 as amended stand part of the bill.
Clause 4, Amendment of Section 4, Powers, Functions, and Duties of Financial Reporting Authority.
The amendment was previously moved to clause 3 when clause 2 was done. So if there is no debate, I'll put the question on that amendment. That's okay. The question is that clause 3, as amended, stand part of the clause. All those in favor, please say aye.
Aye.
Those against, no. The ayes have it. Clause 3 as amended now stand part of the clause. The question is now that clause 3 as amended stand part of the bill. All those in favor, please say aye.
Aye.
Against, no. The ayes have it. Clause 3 as amended now stand part of the bill.
Clause 4, amendment of section 15, conditions for making of order. Clause 5, amendment of section 115, detention on seized cached. Clause 6, amendment of section 145 regulations. Clause 7, amendment of schedule 6, list of activities falling within the definition of relevant financial business.
The question is that clauses 4 through 7 stand part of the bill. All those in favor, please say aye.
Aye.
Against, no. The ayes have it. Clauses 4 through 7 now stand part of the bill.
A bill for a law to amend the Proceeds of Crime 2016 revision to make further changes necessary for compliance with international standards relating to the prevention of money laundering, terrorist financing, and proliferation financing, and for incidental and connected purposes.
The question is that the title stand part of the bill. All those in favor, please say aye.
Aye.
Against, no. The ayes have it. The title now stand part of the bill.
Misuse of Drugs Amendment Bill 2016, Clause 1, short title. Clause 2, amendment of Section 2 of the Misuse of Drugs Law 2014 revision, definitions and interpretation. Clause 3, insertion of Section 2A, authorized use of cannabis extracts, etc. Clause 4, amendment of Schedule 1, controlled drugs.
The question is that clauses 1 through 4 stand part of the bill. All those in favor, please say aye.
Aye.
Against, no. The ayes have it. Clauses 1 through 4 now stand part of the bill.
A bill for a law to amend the Misuse of Drugs Law 2014 revision to include cannabis extracts and tinctures of cannabis as controlled drugs, and to restrict the power to prescribe cannabis extracts and tinctures of cannabis to a medical doctor and for incidental and connected purposes.
The question is that the titles do stand part of the bill. All those in favor, please say aye.
Aye.
Against, no. The ayes have it. The title now stand part of the bill.
The Criminal Record Spent Convictions Bill 2016, Clause 1, short title and commencement.
The question is that clause 1 stand part of the bill. All those in favor, please say aye.
Aye.
Against, no. The ayes have it. Clause 1 stand part of the bill.
Clause 2, interpretation.
I recognize the honourable member from Northside for an amendment.
Yeah, Madam Chairman, I had filed an amendment to clause 2 to delete B under the definition of conviction, because I don't think we should be dealing with convictions in other countries. Shouldn't be what you're convicted here for, or rehabilitation law.
I recognize the honourable Premier.
Madam Chair, we explained this or I did in considerable detail in my response, as did, I think, the Honorable Attorney General. For the benefit of the member, let me repeat again that in order for the bill that we are now dealing with to be efficacious, it needs to have reciprocity. We have, Madam Speaker, to be able to address these issues as they arise with respect to nationals from other countries if we expect the expungement of records, criminal records in these islands by our people to be properly recognized in other jurisdictions. Otherwise, one of the principal purposes of the bill in terms of rehabilitation and giving back to persons who have paid their debt to society and lived a crime-free life to be able to resume things like international travel will not be possible. That's why we can't expect, for instance, the United States to recognize our expungement of records and issue visas for our people if we are not going to reciprocate. Hence, those sorts of provisions that the member is referring to.
If there are no member from Easton.
Madam Chair, I believe that the Premier needs to explain that to us a little better. I know he will make it his. You can't do any better on that. Well, Madam Chair, part of this law says that once that record has been expunged, you need not set down in any requirements asking of a conviction if you don't have to, and no one can ever use it against you.
Madam Speaker, within a category of offenses, there is a long and types of employment. There is a long list in the bill which sets out that with respect to certain offenses, they can never be expunged. There's also a long list of types of occupations where, notwithstanding the expungement, you have to disclose the fact that you did have a conviction. And all of those are set out in the bill.
Thank you. Now, Madam Speaker, Madam Chair, since that's the case, can we be told now then if those countries that we are talking about other than us are expunging the records from here over there, or do we, when ours are expunged here, will they be recognized over there without them being expunged over there?
He's using these big words. That's not the point.
Madam Chairman, I just had a quick consult with the Attorney General on this point. Madam Speaker, the answer is yes. If your record is expunged and you are filling out an application for a visa, and the question is, have you ever been convicted of a criminal offense? If your record has been expunged, you can properly answer no. And that is so because American law will recognize our legislation here as having that effect.
Okay, Madam Chair. So then, Madam Chair, having heard that explanation, why then not our law recognize when theirs have been expunged over there? Why do we have to expunge it here?
Honorable Premier.
Madam Speaker, we're going over territory that has been dealt with in the principal debate both by myself and the Attorney General. We've explained that in practice, this is what happens in Cayman. Anyhow, when an application for a work permit, as an example, is made, and the individual discloses that they have had a conviction for a particular offense, it is compared with our list of offenses, and if the spent period in Cayman has expired, immigration treats it as though it is a spent conviction. So we are essentially codifying what is and has been a long-standing practice with respect to how we treat convictions in other jurisdictions.
But,
Member from Easton.
Madam Chair, what I want to find out is that when we put down on an application for any other country, U.S., I think was the operative one, that we have had a conviction, do they not use it against us even though it has been spent? Is that the reciprocity that we're receiving?
Madam Speaker, I can't answer that question. I don't know whether the Attorney General can. But what the effect of the law that we are putting in place now is that if the offense has been expunged, you need not, you are capable of answering without lying or without trying to deceive anybody. You are entitled as a matter of law to answer no to a question, have you ever been convicted of a criminal offense? That is the effect of expungement under the law.
Madam Chair, I understand
Member
that.
from Easton.
I understand that. But that should also work in reverse with someone coming here. They are entitled to say no. Why are we going to the trouble of putting in our laws that we will expunge it if it's expunged over there? That is the question. They need to say no too. They need to be like Nancy Reagan, just say no.
Honorable Premier.
Thank you. Madam Speaker, may I have a moment to consult?
Certainly, sir.
Madam Chair, we are in a little difficulty here because it appears that the committee stage amendments which were prepared with respect to this were never filed with the office of the clerk and therefore have not been circulated to members. I'm not sure how best we deal with this except by way of a short suspension to be able to circulate them. Okay, I prefer that. Yes, Madam Speaker. Madam Speaker, on the basis of your advice, I move that we defer further consideration of the committee stage by the committee of the Criminal Records Amendment Bill until later in this sitting in order to be able to circulate the committee stage amendments and that we can move on to consider another bill.
The question is that the Criminal Records Conviction Bill 2016, the consideration thereof in committee stage be deferred until the circulation of the amendments to the said bill in this sitting. All those in favor, please say aye.
Aye.
Against, no. The ayes have it. The bill has been accordingly deferred.
Disabilities, Solomon Webster Bill 2016. Clause 1, short title and commencement. Clause 2, interpretation. Clause 3, National Council for Persons with Disabilities. Clause 4, functions of the council. Clause 5, chair and deputy chair. Clause 6, executive secretary. Clause 7, remuneration of members. Clause 8, immunity. Clause 9, indemnity. Clause 10, disabilities register. Clause 11, registration or deregistration of a person with a disability. Clause 12, access to privileges, interests, benefits, and treatment. Clause 13, personal liberty. Clause 14, right to privacy. Clause 15, access to justice. Clause 16, political office. Clause 17, public life. Clause 18, obstruction of authorized persons. Clause 19, regulations. Clause 20, law binding and crown schedule. The National Council for Persons with Disability.
The question is that clauses 1 through 20, inclusive of schedule, be part of the bill. All those in favor, please say aye.
Aye.
Against, no. The ayes have it. Clauses 1 through 20, inclusive of the schedule, stands part of the bill.
A bill for a law to promote, protect, and ensure the full enjoyment of human rights and fundamental freedoms by persons with disabilities on an equal basis with other persons, and to promote respect for the dignity of persons with disabilities, to establish the National Council for Persons with Disabilities, and for incidental and connected purposes.
The question is that the title stand part of the bill. All those in favor, please say aye.
Aye.
Against, no. The ayes have it. The title now stand part of the bill.
Madam Chair,
Sorry,
Just before
member
you-
from North Side.
just before you move on to the next bill, I understand that there are some amendments that have been filed for the education bill as well, which have not been circulated. So we need to, I would, maybe we can, you want to take a break or get them out because
Honourable member from Northside, the Assembly has been in receipt of them late morning, and I had advised the clerk, because she was going through them, to let's get started committee. I would take an afternoon break so that she could peruse them and then circulate them. So they're into the process. Thank you. No, yours, no. Yeah, the minister did indicate that that was a desire to do,
Yeah, whatever.
yeah. When we come to it, then we'll move, okay.
Yeah.
We're in the development planning bill. Should need to put short, clause 1. Much appreciated.
The Development and Plan Amendment Bill, 2016. Short title, 1 short title, 2, Amendment of Section 13 of Development and Planning Law, 2015 revision, provisions for development. Clause 2, Amendment of Section 18, Enforcement of Plan Control. Clause 4, Amendment of Section 19, Appeal against Enforcement Notice. Clause 5, Amendment of Section 29A, Power to require proper maintenance of land. Clause 6, Repeal of Part 5, 6, Repeal of Part 6, Compensation for the refusal or conditional grant of planning permission. Clause 7, Amendment of Section 40, Service of Notices.
The question is that clauses 1 through 7 stand part of the bill. All those in favor, please say aye.
Aye.
Against, no. The member from Northside.
Yeah, Madam Chair, I just have a general question of the minister. I just want the minister to confirm that these changes are in no way retroactive, because I have had incidents, Madam Speaker, to deal with the electrical inspector trying to retroactively apply changes in electrical regulations to accommodations that were approved under the current regulations 30 years ago. So just make sure it's recorded that it's not retroactive.
By
Honourable Minister.
retroactive, I'm presume, through you, Madam Chair, forgive me. By retroactive, just to be very clear, I'm assuming what you mean is that a structure, for instance, that the electrical components and the electrical plan was passed some time ago, that if we had any subsequent changes after its passage, that those changes can't be levied on the original plan if there are future changes to that structure. Is that what we're talking about?
Basically, let me give you a for instance.
Member from Northside.
For instance, in 1972, a house was approved. The meter height that was allowed at that time was 80 inches. The new regulation says it has to be 60, and I'm just using numbers for it, so 62.5 inches. That 62.5 inches cannot be a requirement if the person just wants to replace the meter socket with no other changes in the bill.
I understand the member's point, and I'm sure when that happened, the matter was cleared away.
Absolutely, but I just want...
And if you want it for the record, I will say so for the record that the member is entirely correct. And if that were to happen to anyone, then someone is misconstruing not only the spirit of the law, but the actual workings of the law.
Those against, please say no. The ayes have it. Clause 1 through 7 now stand part of the bill.
A bill for a law to amend the Development and Planning Law 2015 revision to make further provision in respect of the enforcement of planning control and to make provision for incidental and connected matters.
The question is that the title now stand part of the bill. All those in favor, please say aye.
Aye.
Against, no. The ayes have it. The title now stand part of the bill.
The Election Amendment Bill 2016. Clause 1, short title and commencement. Clause 2, amendment of Section 2 of the Election Law 2013 revision, definitions and interpretation.
The question is that clause 1 and 2 stand part of the bill. All those in favor, please say aye.
Aye.
Against, no. The ayes have it. Clause 1 and 2 now stand part of the bill.
Clause 4, amendment of section 4, appointments, powers, and duties of deputy supervisors. Clause 5, repeal and substitution of section 5, electoral districts and
We have to
Member from Northside, I believe there is an amendment to clause 3.
Yes, Madam Speaker, I propose an amendment for clause 3 to delete clause 1A, B, and C and add the following words: have extensive experience as an elections officer after the word shall, so that the new clause 1 would read, Madam Speaker, the governor shall, in the governor's discretion, appoint no less than 3 deputy supervisors of elections, and those persons shall have extensive experience as election officers. Just to streamline the whole process for the governor, Madam Speaker, because under the current proposal, she has to go through existing public servants. She don't find what she want there. She then has to go to retired civil servants. She don't find what she want there. She then has to go to the public. So why not just give her the option of picking whoever she wants from either of those 3 in the first instance?
Honorable Attorney General.
The man appointed you, sir, not him. The deputy governor anointed you, the attorney general, before you left. No, he said in publicly that the attorney general was going to deal with it, with the law.
Madam Speaker, may I just confirm, because I was told that the deputy governor wasn't prepared to accede to the request for these amendments.
Oh, okay.
May I just confirm?
I'm just trying to simplify the legislation. That's all I'm trying to do. Because I don't know what happens, Madam Chairman, if she refuses to appoint, always in her discretion, a civil servant who has experience. Does he have a right then to claim that should be one of him? And she can't go to retired, or she can't go to the public because they are retired civil servants? All except clause 5. Brings in single.
Sorry, Madam Speaker, but of course, it's a matter for the committee, but the indication, as I understand it, was that the Honorable Deputy Governor, having considered the issue, was minded to accede to the request for those amendments. So it's a matter for this committee as to whether or not they want to
Put it to the vote.
put it to the vote.
Sorry, would the Honorable Attorney General be so kind as to repeat what you just said? I was not able to understand or hear.
Thank you, Madam Chair. I indicated that obviously it's a matter for this committee as to whether or not the amendments are accepted. But my understanding is that the Honorable Deputy Governor, having considered the matter, has decided that he was minded to accede to the amendments proposed by the honorable member from Northside. But of course, it's a matter for this committee as to whether or not the committee.
Yeah, that's what I was trying to seek some
Was not-
clarification on, but I think I
Was not
understand.
willing to accede, Madam Speaker.
Madam Chair, can I, just for clarity, is that for all the amendments that I filed? Because I don't want to waste the time of the House. If he not going to accept any of them, I'll just withdraw them all now.
Honorable Attorney General.
Yes, Madam Speaker, that's my advice. Thank you.
I guess the other clarification from the chair, because there was some crosstalk. I just want to make sure that I understood correctly when you said that the Honorable Deputy Governor, after having considered the matter, did not accede to the. That's what I wanted to clarify, because he didn't say after consultation with the government or the committee. So I just want to make sure for the record, because that could become an issue.
I'm assuming, Madam Speaker, that he would have done all of that. But as I said, he mentioned it's a matter for this committee, because the committee can vote otherwise. But he was the one who moved the second reading. He listened to the contributions, and at the end of it all, he said that the only amendment he was agreeing with was the one that was put forward by him.
Madam Chair, if I can.
Honorable Premier.
Madam Speaker, the Honorable Deputy Governor spoke to me, and he said that his recommendation was to the government was not to agree to the amendments other than the one that is circulated by the government relating to.
Clause 15 and 34.
Yes, ma'am. Clause 15 and 31. Yes.
Thanks for clarifying the procedure, Honorable Premier, for the purposes of the record. Honorable Member from Northside, is your position still the same based on what's just been said?
No, Madam Speaker. We vote on everyone, so I can record him in the hands out because he didn't consult me. So this committee, I can file every amendment, and we will vote. If they want to vote them down, they vote them down on his instructions. But if he didn't have the respect to mention it to me, then I'm not about to withdraw it. So put it to the vote.
They were circulated, I can ask another copy. Kim?
I was off the other when you debated the bill. No. Don't worry about that.
Does,
But I also know
can the
what-
chair just inquire, beg your pardon, whether all members are in possession of Mr. Miller as a member from Northside amendments? 'Cause the leader opposition does not have them. I want to make sure. I see the fifth elected member. I just want to make sure that while we're going through this process and putting it to the vote, members know what they're voting on. So if you could give the Sarge a few minutes. Did anybody get them?
Yes.
Okay. So if the chair could beg your indulgence until the Sarge come back in, hopefully it'll just be momentarily. No, Vincent, no, either. I didn't have either. Oh, no. Yeah, I got them separate, otherwise I'll get confused. Fifth elected member from Georgetown, you need a copy as well? Okay. The honorary minister responsible for finance also need a copy. The deputy premier needs a copy. Fourth elected member. Can we just bring copies for almost everybody? Members, the chair would wish to remind you that we have not suspended, so unless you want the public to hear some of your laughter, please refrain from making some of your utterances. The copies of the amendments. Yeah. Members, while we're waiting on the copies for the election law to be circulated, can we have the consent of the committee to move on to the disaster preparedness and hazard management provisions? Disaster.
The Disaster Preparedness and Hazard Management Bill, 2016. Clause 1, short titling commencement. Clause 2, definitions. Clause 3, establishment and staffing of the department. Clause 4, functions of the department. Clause 5, powers of the director. Clause 6, responsibilities of the director. Clause 7, establishment of a national emergency notification system. Clause 8, national emergency notification system. Clause 9, emergency shelters. Clause 10, information to be supplied to the director. Clause 11, community service activities. Clause 12, national migration plan, vulnerable areas. Clause 13, disaster area or hazardous area. Clause 14, National Hazard Management Executive and Council. Clause 15, Director to establish a liaison with the private sector. Clause 16, appointment of consultants and experts. Clause 17, immunity and indemnity. Clause 18, obstruction, refusal to furnish information. Clause 19, unlawful entry into disaster area or hazardous area. Clause 20, regulations, schedule, organization and composition of management executive and management council.
The question is that clauses 1 through 20, inclusive of schedule, be part of the bill. All those in favor, please say aye.
Aye.
Against, no. The ayes have it. Clauses 1 through 20, inclusive of the schedule, is now part of the bill.
A bill for a law to establish a Department of Disaster Preparedness and Hazard Management for the purpose of managing emergency situations affecting the islands and to make provisions for incidental and connected matters.
The question is that the title now stand part of the bill. All those in favor, please say aye.
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 Against, no. The ayes have it. The title now stand part of the bill.
The Procurement Bill 2016. Clause 1, short titling commencement. Clause 2, interpretation. Clause 3, application. Clause 4, principles.
The question is that clauses 1 through 4 stand part of the bill. All those in favor, please say, please say aye.
Aye.
Against, no. The ayes have it. Clauses 1 through 4 now stand part of the bill.
Clause 5, procurement code of conduct.
Honorable Minister, I believe you have an amendment. Minister of Finance.
Yes, thank you, Madam Chair. Madam Chair, in accordance with Standing Order 52, subsection 1 and 2, I move that the following amendments be made to the bill. Madam Chair, in Clause 5, 1D, by deleting the word confidentiality. In Clause 18, as follows.
Honorable Minister. Clause 5, and then we'll do one
Sorry.
at a time. That's okay.
Just trying to get out of here.
I would second that, but I don't have the prerogative. The amendment has been duly moved. Does any member wish to speak to the amendment as moved? If not, the question is that Clause 5 as amended stand part of the clause. All those in favor, please say aye. Against, no. The ayes have it. The amendment stand part of the clause. The question is that Clause 5 as amended stand part of the bill. All those in favor, please say aye.
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 Against, no. The ayes have it. Clause 5 as amended now stand part of the bill.
Clause 6, Central Procurement Office. Clause 7, Director. Clause 8, Public Procurement Committee. Clause 9, Roles and Functions. Clause 10, Entity Procurement Committees. Clause 11, Constitution of Committees. Clause 12, Operations of Committees. Clause 13, Procurement Methods. Clause 14, Procurement Valuation. Clause 15, Direct Award Process. Clause 16, Economic Development Preference. Clause 17, Local Benefits Tests.
Question is that clauses 6 through 17 stand part of the bill. All those in favor, please say aye.
Aye.
Against, no. The ayes have it. Clauses 6 through 17 now stand part of the bill.
Clause 18, Confidentiality.
Honorable Minister, there's a proposed amendment to Clause 18.
Thank you, Madam Chair. Madam Chair, I propose to amend Clause 18 in subclause 1 by inserting after the words that information is the words required by law or. In subclause 2, by deleting the words pursuant to this law and substituting the words required by law. In subclause 5, by deleting the words relating to the procurement confidential and substituting the words relating to the procurement project confidential, subject to any disclosure required by law or by order of a court. And in subclause 6, by deleting the words assign the public officer who shall. Continue.
No, sorry, I was just consulting. Thanks. The amendment has been duly moved. Does any member wish to speak to the amendment to clause 18? A member from North Side?
Yeah, through you, Madam Chairman, in clause 5, will the amendment allow the process to be subject to FOI?
Honorable Minister of Finance.
Thank you, Madam Chair. Madam Chair, it is not intended that it would override any provisions of the FOI law, Madam Chair.
Member from North Side, do you have a follow-up? Are you satisfied with the response?
So the requirement that this whole section faces on confidentiality does not prohibit FOI information.
Madam Chair, Madam Chair, I am informed that the deletion was based on a request from the acting information commissioner, and it pertains to the future procurement code of conduct as we are dealing with here. The code of conduct is not intended to override any provisions of the FOI law or the National Archive and Public Records law. Madam Speaker, it is believed that the code of conduct should focus strictly on record keeping and disclosure requirements rather than potentially create a possible conflict with the FOI law or the National Archives and Public Records law, which defines treatment of confidential information, Madam Chair.
If there are no further questions, I put the question that the amendment stands part of the clause. All those in favor, please say aye.
Aye.
Against, no. The ayes have it. The amendment now stand part of the clause. I put the question at clause 18 as amended, now stand part of the bill. All those in favor, please say aye.
Aye.
Against, no. The ayes have it. Clause 18 as amended, now stand part of the bill.
Clause 19, immunity. Clause 20, regulations. Clause 21, savings and transitional.
I put the question at clauses 19 to 21 stand part of the bill. All those in favor, please say aye.
Aye.
Against, no. The ayes have it. Clauses 19 to 21 now stand part of the bill.
Schedule 1, principles of procurement.
Honorable Minister of Finance has a proposed amendment to Schedule 1.
Yes, thank you, Madam Chair. Madam Chair, in Schedule 1, propose to delete paragraph 12 and substitute the following paragraph. Transparency. Public sector entities should ensure that there is openness and clarity in the conduct of the procurement policy, including in the carrying out of all actions and decisions.
The amendment has been duly moved. Does any member wish to speak to the amendment? Member from North Side.
Yes, Madam Speaker, I had filed an amendment earlier to delete that section, and as long as the minister will include the public tendering aspect of it, open tendering aspect of it, that is, where bids are opened in public, because I don't think that what he's offering gives the transparency that I believe is necessary.
Honorable Minister for Finance.
Thank you, Madam Chair. Madam Chair, I've discussed this matter with my technical staff, I've discussed it with my colleagues, and Madam Chair, I am unable to support the proposed amendment by the honorable member from Northside. And Madam Chair, with your permission, I would like to read into the record a short letter written by Marilyn Brown and originally published in the summer 2013 edition of Caveat Emptor, the magazine of the Ontario Public Buyers Association. Thank you, Madam Chair.
Consent given.
Thank you, Madam Chair. It has long been assumed that public openings where tenders are opened and bid prices are read aloud in the presence of bidders enhance the transparency of the bidding process. But do public openings actually achieve the intended result? Unfortunately, some measures designed to increase transparency can have the undesirable effect of facilitating bidder collusion and anti-competitive practices. Evidence before the recent Charbonneau Commission investigating corrupt procurement practices in Quebec reminds us that organized crime can use a public opening process to intimidate bidders and discourage bids from suppliers who are not part of the bidding cartel. Public sector organizations need to look again at public openings. A number of international sources cast doubt on the merits of public openings. The supplement to the 2011 Annual Statistical Report on United Nations Procurement, Ensuring Integrity and Competition in Public Procurement Markets, a dual challenge for good governance. Madam Chair, that was the title of the United Nations procurement document, argues that the public opening of tenders makes it much easier for a bidding ring to police its members. While widely seen as an anti-corruption measure, public openings of tenders can also facilitate collusion by enabling cartel members to determine whether co-conspirators fulfilled promises either not to bid or to submit artificially high cover bids, thereby increasing cartel stability. Curbing Fraud, Corruption, and Collusion in the Road Sector, published by the World Bank's Integrity Vice Presidency, notes that cartel procurement began to decline in the 1990s, where public openings of bids was abolished. The United States Department of Justice issued an antitrust primer entitled Price Fixing, Bid Rigging, and Market Allocation Schemes, What They Are and What to Look For, which concludes that public openings favor collusion. Bidders who congregate in the same building or town to submit their bids have an easy opportunity for last-minute communications. The OECD's guidelines for fighting bid rigging in public procurement identifies signs of collusion and bid rigging, including the practice of bringing multiple bids to a bid opening and choosing which bid to submit after determining or trying to determine who else is bidding. There are clearly good reasons to be skeptical about the merits of public openings, but are they required in this context? Madam Speaker, Madam Chair, the author is from Canada. This was written in Canada, And with respect to the Canadian context, it says, although some public sector organizations in Canada have elected to provide for public openings in their internal policies and procedures, and some Canadian jurisdictions have made public openings mandatory, neither Canadian common law nor binding international or domestic trade agreements require that bids be opened in public. All organizations should confirm their obligations under their governing statutes and regulations with their legal advisors. But many Canadian public sector organizations are not subject to any obligations to open bids in public. And Madam Speaker, it goes on to speak about the agreements such as NAFTA and the World Trade Organization Agreement of Government Procurement. They do not require tenders to be opened in public. It speaks of the Canadian Agreement on Trade, on internal trade. Again, tenders may not necessarily be opened in public. And the Ontario's Management Board of Canada's procurement directive suggests that only bids be opened in the presence of at least one witness. Madam Speaker, in closing, the letter says that public sector entities engaged in procurement can actually suffer from an excessive public process. While intended to facilitate fair and open competition, public openings of tenders can cause more harm than good. In the Canadian context, protection against internal corruption and impropriety in the opening of bids and the recording of bid prices is available in simple measures, such as a requirement that bids be opened and recorded in the presence of at least two individuals, including a representative of the procurement department. A less public bid opening process can sometimes result in more bidding transparency. Consider closing the door to the bid opening room. Madam Chair, with your permission, I'd like to table a copy of this letter, Madam Chair.
So ordered.
Thank you.
Madam Chairman,
Member from
I'm sure that given time,
Easton.
I could find many articles that would
So that when you call the chairwoman a chairman, I call you the member from Easton. Member from Northside.
My apologies, Madam Chair, lady. But I'm sure given time, I could produce any number of articles that contradicts, and the minister is not really seriously concerned about or suggesting that we have all of this bidding mafia and bidding cartels and bidding rings in Cayman. And what I can't comprehend is what is the government's aversion to open tendering, where everybody, because the perception of what is going on now is that the tendering process is unfair. And maybe the reason for that is probably why we have Section 2 on the Schedule 5 that says we're going to give the documents to the procurement committee members 5 days before the meeting so they can have time to deal with all these cartels and stuff around.
Honorable Minister for Finance.
Thank you, Madam Chair. Madam Chair, I just spoke of the Canadian context from a lady by the name of Marilyn Brown, who, with all due respect, Madam Chair, has a great deal of experience in this area, and more so than any of us. I will now deal with the concerns of the existing Central Tenders Committee, the practicalities and the difficulties that would arise with opening the bid process to the general public. Madam Chair, this is all to do with transparency. So I will read it as it's been written, with your permission. Interestingly, this suggestion was considered by the Procurement Law Committee, and after some discussion, considered unworkable, this consideration being opening the bids in the presence of the general public. The Public Procurement Committee is a successor body to the Central Tenders Committee and essentially carries out the same function, which is one of oversight, not decision-making. The Procurement Law Committee, or otherwise called here the PLC, the Procurement Law Committee, believed that opening these meetings to the public, whilst clearly improving transparency surrounding public sector procurement, would likely frustrate the procurement process and may make it difficult or impossible to reach decisions in a timely manner. I feel that Central Tenders Committee currently gets through all agenda matters in a very timely manner, and this is critical to the ministries, portfolios, public authorities, and government-controlled companies that we deal with. Please remember that whilst we have 2 scheduled meetings a month, we also meet on an ad hoc basis as necessary and convene bid opening meetings as necessary, and oftentimes at short notice. I could envisage public sector procurement grinding to a halt if these meetings were made open to the public. That said, we must improve on the matter of transparency. At present, CTC posts its meeting minutes to our website. I believe there needs to be a process going forward whereby the tender evaluation reports also are made public. This is the key document prepared by the ministry, which justifies the contract award recommendation. The public would then have access to all key information. Whether or not the actual contracts are then also made public is another interesting question. Madam Chair, in addition to that, the key impediments, Madam Chair, to opening the public procurement meetings to the public include, number one, notice of meetings would be an issue. As stated, the Central Tenders Committee has many ad hoc meetings, probably as many as the scheduled meetings, and certain approvals are conducted by way of round robin. This would not be possible for the Public Procurement Committee if reasonable notice had to be given to the public, which could significantly slow down the procurement process and cause frustration to the procuring entities. Number two, dealing with conflicts of interest is an ongoing issue. I don't see how we could sensibly deal with the members of the public who may be conflicted but nevertheless wanted to attend. In fact, it may well be that we would attract a disproportionate percentage of conflicted persons whose intent was to influence the outcome of the procurement process. Number three, free and open discussions between the members of the Public Procurement Committee is critical to the decision-making process. I believe public participation in these meetings would impede such discussion and decision-making. And number four, I believe there would be significant reluctance on the part of the private sector to serve on the Public Procurement Committee. Possibly, the mere name of the Public Procurement Committee has inadvertently created an assumption that there should be public participation. In my view, this is unfortunate, as I see almost no difference between the role of the Public Procurement Committee and that of the Central Tenders Committee, which does not have open meetings. So, Madam Chair, finally, Madam Chair, while it seems counterintuitive, the findings around the world have been that public openings actually do more to sustain bid rigging and corrupt business practices than they do to promote transparency. Organizations like the World Bank, now discourage the practice and instead encourage better reporting and the use of technology, such as e-bidding, as ways to enhance transparency. So, Madam Chair, for the reasons given, as extensive as they have been, we are unable to support the proposed amendment to the law.
Madam Chair.
Recognized Honorable Leader of the Opposition.
Madam Chair, I am glad, and I didn't speak on this bill, didn't get a chance, but I'm glad to see this bill here because for years we've talked about getting a new process. And that was attempted by us, myself, the Deputy Governor at the time, Donald Ebanks, and Mr. Manderson, who was acting or was in the ministry at the time, or in the portfolio at the time, and I think the financial secretary. The delegation to Jamaica that went and looked at the Jamaican system and had worked out a plan to get changes. And I'm glad that we are getting some changes because over the years there's been so much speculation and there has given leave for people to make all kinds of accusations, particularly so on elected officials. And this, I think, will help alleviate that. Mind you, anyone that want to make accusations can do so. And people of evil mind will do so. The only thing the good Bible say is that whatever he thinketh in his heart, so is he. But in listening to what the member from the outside is trying to get and what the minister is arguing against, it seemed to me that we always thought, it was always a train of thought here that public opening was a very safe way because it eliminated all the suspicion and everything else that goes with it. And I tell you the truth, when it comes, there are many, many institutions around the world that can help us and has helped us frame legislation to do all sorts of things that's good for us. But many of them are suspect themselves. All sorts of things have gone on there, but there's the same ones that come here and lay down the rule about corruption, and you can't find more corruption than what you find in some of those places. That's a fact. The bid rigging, the collusion, I feel that if we did something in a public opening, it's going to eliminate all of that. I think the government, in following whatever Canada does, and when you go in and read some of what happens there, you don't want that to happen here. I think if we don't do something like the public opening, it is going to not give us the transparency that I think we need, and we have got to the point where we got a good bill, I think. And I hope that from here on in, it will eliminate all the suspicions and all the accusations and the finger pointing. But if we leave it to where people can still do that and still come and say, he's still done something for his business partner, and he got this one on the board, no matter who appointed who, it can still come. And we as a house ought to, and that's what we've been trying to do, I think, now, is to get all of that eliminated as much as possible. I would implore the government to have a relook at that thing called public opening, because I don't see anything else in this bill that is going to do that aspect of it that I believe is absolutely necessary. Thank you, Madam Chair.
Madam Chair.
Member from Northside.
Just to respond to some of the things that the Honourable Minister said. Open tendering will cause the process to be grinded to halt. Got one word for that, laziness. Deal with public participation. There's no public participation envisioned or expected or authorized in open public tendering. We're not changing the role of the Central Tenders Committee. What we bring this bill for? If we're going to transfer all of the procedures that the current Central Tenders Committee enjoys and is causing all the problems that we're having in terms of public perception of whether these bids are rigged or not, and we're going to carry all of that forward, what's the point of the legislation? And Madam Speaker, I don't know what the government believes public tendering is, or opening in public open tendering. There's no public participation. I did it for the Dr. Horter Hospital. You simply open the envelope. This bid is from Ezard Miller. It's $5,000. That's announced. There's no opportunity for the public or tenderers to participate. So why are we want to remain the only country in this region that doesn't have open public tendering?
Madam Chair, I have
Honourable Leader of the Opposition. And
thank
then-
you. One question to the Minister. If you don't go to public opening bid, what then is going to be the process?
Honourable Minister of Finance, after which I want to put the question.
Thank you, Madam Chair. Madam Chair, the process would remain as it is, where the documents are received and they're open and the information is recorded. But there's something that the chairman of the Central Tenders Committee thinks would help alleviate the concerns about anything being done untoward, and that is the release or publication of the evaluation, the tender evaluation reports. And the law, the bill stipulates or provides that the award and all supporting information and the minutes are to be made known public and published within 30 days of the decision to award the contract. In addition to that, Madam Speaker, there is the debriefing exercise that the bill also provides for, where unsuccessful bidders are able to come and have a sit-down discussion and understand why they were unsuccessful.
Madam Chair, if the Minister, if you may, or you would,
Honourable Leader of the Opposition.
the bid is sent in not to a committee and then go to central tenders or whatever you're going to call it. It goes straight to them. Am I right?
Honourable Minister of Finance.
Madam Chair, let me confer on the exact process because it's not something I've ever observed.
Okay.
Madam Chair.
Honourable Minister for Finance.
Madam Chair, depending on the threshold and the value of the procurement, Madam Chair, if it's less than 250, it would fall to the Entity Procurement Committee, and the chief officer in publishing the bid opportunity would stipulate to whom the bid documents should be returned, be it the chief officer or a designated person within the entity. And if it is more than 250,000, then it would go to the secretary of the Public Procurement Committee.
Just to be clear, the
Honourable
only,
Leader of the Opposition.
thank you. The only body then is those two people you just spoke about and the procurement committee, and that's the one that is outlined in the bill, the new construct, new members and all this.
Yes.
Am I right?
Yes, sir. The two committees, one being the entity committee that would deal with procurement contracts for less than $250,000, and the other committee being the public procurement committee dealing with procurement contracts in excess of $250,000.
Madam Chairman, again, the government has the votes and they will do what they want. But I'm sure all of them over there understand quite where I'm coming from. The safeguards are not in this bill. The safeguards are not there. Smart people will get around it. And I believe that the opening, no matter what they say in Canada, the open bidding or public opening is going to safeguard. They can't do one thing about it when they write that there unless members of the committee are biased. We've had cases here, we know what happened to the chairman before. We know what has happened in recent times, or so it was painted that way, I don't know. But we want to eliminate all of that.
Thank you, Madam Chair. Madam Chair, I think we as legislators need to accept that there is no piece of legislation that mankind hasn't figured out how to overcome. That is why you have to ensure that you look for people with principles and integrity when you appoint them to committees. And Madam Chair, the fact is, even the World Bank, who obviously has a great deal of experience with respect to procurement contracts, has opined that the opening of bids in public do more harm than good. It is a new piece of legislation, Madam Chair, and it is expected that as time goes on, we will identify ways of improving upon it, but with all of the information we have available to us, it is deemed not in the best interest of the country to move to an open bid process.
The question is that the amendment stands part of the schedule. All those in favor, please say aye.
Aye.
Against, no.
No.
I believe the ayes have it.
Madam Chair, can I have a division on that point?
Yeah.
Madam Clerk, please take a division, and we're dealing with Schedule 1 and we're dealing with the government's amendment. There's also an amendment from the member from North Side on the same Schedule 1.
Honorable Alden McLaughlin.
Aye.
Honorable Moses McConnell.
Aye.
Honorable Kurt Tibbetts. Honorable Osmond Barton.
Aye.
Honorable William Panton.
Aye.
Honorable Marco Archer.
Aye.
Honorable Tara Rivers.
Microphone can hear you. You need to say it into the microphone.
Mr. Roy McTaggart. Mr. Joseph Hugh.
Aye.
Honorable McKeever Bush.
No.
Mr. Barney Bush. No. Mr. Captain Eugene Ebanks.
No.
Mr. Alva Saku.
No.
Mr. Winston Connolly.
No.
Mr. Ezra Miller.
No.
Mr. Ard McLean. Mr.
No.
Honorable Anthony Eden.
No.
The results of the divisions are as follows: 9 ayes, 8 noes. The ayes is carried. Recognize the member from Northside. Do you still wish to put forward your amendment to Schedule 1, sir?
Yes, Madam Chairman, they should have an opportunity to vote against this. My amendment is to item 12 of Schedule 1 by deleting the existing clause and substituting the following. Public sector entities shall ensure transparency by utilizing public tendering procedures. That is, all bids shall be opened in public and the name of each bidder and the amount of their bid is announced publicly when the bid envelope is opened.
The amendment has been duly moved. Does any member wish to add anything further? If it's not,
Madam
member
Chairman,
from our side.
Yeah, I would just explain that this amendment calls for no public participation. The public who attend, the bidders who attend, are not allowed, are not expected, are not intended, are not given the opportunity to participate. They simply hear, and the general public hear, what each person bid. And again, it doesn't carry any expectation that the decision of who the successful bidder is made at such a public opening of the tender. That is reserved for whatever committee that they have to do the analysis. All is simply done is you open envelope A, it comes from John Jones, you announce the amount for each of the bids. All of the bidders that they currently do, the government always carries the caveat they don't have to accept the lowest bidder. None of that is impacted, but the fact is that the public knows what each bid was for that particular procurement that was sent out.
The question is that the amendment proposed by the member from Northside to Schedule 1 stand part of the clause. All those in favor, please say aye.
Aye.
Against, no.
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 I believe the noes have it.
Can I have a division, please?
Certainly, Madam Clerk, please call a division.
Honorable Alden McLaughlin.
No.
Honorable Moses Kirkconnell.
No.
Honorable Kurt Tibbetts. Honorable Osborne Bodden.
No.
Honorable William Panton.
No.
Honorable Marco Archer.
No.
Honorable Tara Rivers. No. Mr. Roy McTaggart. No. Mr. Joseph Hugh.
No.
Honorable McKeever Bush.
Aye.
Mr. Barney Bush. Aye. Captain Eugene Ebanks.
Aye.
Mr. Alvis Saku.
Aye.
Mr. Winston Connolly.
Aye.
Mr. Ezra Miller.
Aye.
Mr. Arden McLean.
Aye.
Honorable Anthony Eden.
The results of the division are as follows: 8 ayes, 9 noes. The amendment has failed. The question is that Schedule 1, as amended by the government, now stand part of the bill. All those in favor, please say aye.
Aye.
Against, no. The ayes have it, I believe. Schedule 1, now, as amended by the government, now stand part of the bill.
Schedule 2, Director of Central Procurement Office. Schedule.
The question is that Schedule 2 stands part of the schedule. All those in favor, please say aye.
Aye.
Those against, no. The ayes have it. Schedule 2 now stands part of the bill.
Schedule 3, Constitution of the Public Procurement Committee.
There is a proposed amendment by Mr. Miller, the member from Northside.
Thank you, Madam Chairman, yes, Madam Chairman, I propose an amendment to Schedule 3, which will do what the government announced on Radio Cayman, remove politics from the procurement committee, which the current schedule does not do. Because the current schedule in 2 says the governor, acting in accordance with the advice of the premier, shall appoint from persons in the private sector the chairman and 3 other members of the public procurement committee, one of whom shall be an attorney at law. And Section 3 says the governor, acting in accordance with the advice of the leader of the opposition, shall appoint from persons in the private sector 1 member of the public procurement committee. And what amendments I have filed, Madam Speaker, is to delete those. And the first thing, to delete the word 8 and substitute 5, because I don't see why they're putting a procurement committee together with an even number of people. And to substitute the following: the governor shall appoint 5 persons from applications received through an open recruiting process by placing advertisements in the local press on 3 consecutive days that include qualifications, skills, utilities, and compensation.
Utilities or duties?
Duties, I'm sorry. And deleting subclause 3 and 4. And in clause 6, remove the word gazette and substitute in the local press. Because most of the people who have interest in this don't see the gazette.
Okay, the amendment has been duly moved. As any member wishes to speak or recognize the honorable leader of the opposition?
Madam Chair, this certainly would give it the non-political avenue, if I would put it that way. But to me, giving it to the governor by him or herself is not something that McKeown Bush can support. We've had too many other ones them around place. I can't support that. Yes, but they're still appointing from applications. They still have the wherewithal to do their usual things to get who they want. And that, I don't think that gives us the safeguards that we need and having people who are capable to go there. The governor is known to appoint their own people, eh?
Honorable Premier.
Madam Speaker, sometimes I wonder, really. Mr. Miller is one who generally proposes that as a country, as a government, we should have more as a House and members of the House. We should have greater autonomy and control over the direction of the country. But occasionally, he proposes things which would take the country back to where it is the United Kingdom who make key decisions. I could never, in 100 years, support a proposal which transfers this responsibility from those who have been elected by the people and who the people can decide whether they're doing a good job or not, and give it to a UK-appointed governor. All of the battles that we have fought, and I have fought as many of them, if not more, than just about anybody, to get this country to a point where we have greater control of our destiny as elected members. To adopt a regressive step like this is not something that I could ever support.
Honorable member from Northside, do you wish to reply to your amendment?
Sure, Madam Speaker. Madam Speaker, they're the government who announced on Radio Cayman that they wanted politics out of it, not me. And if the premier is so adverse to the governor, I don't have a problem with cabinet doing it once this process is followed. But I think we know what has been happening here over the last several decades when it comes to appointing people to important committees. And whether you want to call it regressive or not, it's the same 6 or 7 people that get nominated for everything. And we have to find a way to give Caymanians who wish to participate in this process and feel that they're qualified to do so, to make an application for some of these positions and express their desire to serve the country other than relying solely on the political directorate to nominate them. Because I don't think that that is so progressive either.
Madam Chair.
The Honourable Minister for Finance.
Madam Chair, with the greatest respect to what the honourable member is proposing, I think if you look at the practicality of the suggestion, there is no way of determining how many people would apply for these positions as board members. And you could end up with 10, you could end up with 100 with varying qualifications and experience. And you would then spend a significant amount of time trying to vet who should be appointed. Madam Chair, it's quite conceivable that the applications would come in, a committee would be set up to vet the applications, and then a report would have to be written to recommend the successful applicants. That would consume a lot of valuable time. And all that time, you could have been dealing with the actual bid process itself. So, Madam Chair, there's a growing number of young, qualified, professional Caymanians who are able and willing to serve on some of these committees, and therefore the pool from which we are able to nominate board members and committee members is growing. I don't think that we would be stuck with the same small number that we currently have. So, Madam Chair, looking at the practicality of it, I don't think the application process has the merit that the member has proposed.
Honourable Member from Easton, and after that I'll put the question.
Madam Chair,
Captain Eugene, you had it? Oh.
Madam
Member
Chair,
from Easton.
there seems to be a little confusion over here because the Minister for Works is proposing in one coming out that we advertise. And whilst I may sort of lean a little bit towards the Premier, I don't know if we're going to, in accordance with the Premier, move ahead and take a rightful place with that little bit of autonomy and claw at it each time, then I don't know how the Minister of Finance now is saying that it's not necessary to do it in the way the member from North Side is proposing, which is the open request or our application. And I believe that the government is saying that they're also bringing the authorities appeals law. And would that not include, it used to include, I believe, people applying to go on that authorities, that committee. I don't know what it will be next. But what I'm saying, Madam Chair, we can't have two different systems then. And let Mr., if we're not going to do it, we're not going to do it. But in a few minutes, we will be approving one that people have to apply for under the competition law.
Honourable Minister of Finance, I was going to put the vote, but I saw you hold on to your mic. You wish to say something?
No, Madam Chair, I was just checking to see if my microphone was on. Thank you, ma'am.
The question is that the amendment to Schedule 3 stand part of the clause. All those in favour, please say aye. Aye. Those against, no.
No, it's the wrong way around.
The ayes have it.
We need to identify which amendment we're talking about. There's too many amendments on the thing.
That's the only one now.
Madam Speaker, can we have a division, please?
Madam Clerk, please call for division.
Yeah, Madam Chair, could we be certain as to which?
Could I ask all members to please pay attention? We're now on the notice of committee stage amendments. We're on amendments submitted by Mr. Miller, the member from North Side. We're dealing with Schedule 3 to the amendments, which is on the first page of the amendments he submitted. We've already disposed with the government amendment, and the government has no amendment to Schedule 3.
Honorable Alden McLaughlin.
No.
Honorable Moses Kirkconnell. Mr. Honorable Kurt Tibbetts.
No.
Honorable Osmond Bodden.
No.
Honorable Wayne Panton.
No.
Honorable Marco Archer.
No.
Honorable Tara Rivers. Mr. Roy McTaggart. Mr. Joseph Hugh.
No.
Honorable McKeeva Bush. Mr. Barney Bush. Campton Eugene Ebanks.
Aye.
Mr. Alva Saku.
Aye.
Mr. Winston Connolly. Wait. Sorry.
You know, you're,
Mr. Ezra Miller.
aye.
Mr. Arden McLean.
Aye.
Honorable Anthony Eden.
Exactly.
Can I just remind members when they vote to please vote with your mic on, because when the transcripts are typed, it's going to be confusion. The result of the division are as follows: 4 ayes, 11 noes, 2 absentees. Therefore, the amendment is not carried.
Schedule 4, the responsibilities of the Public Procurement Committee.
The question is that Schedule 4 stands part of the bill. All those in favor, please say aye.
Aye.
Those against, no. I believe the ayes have it. Schedule 4 now stands part of the bill.
Schedule 5, meetings of the Public Procurement Committee.
Recognize Mr. Miller from Northside for the proposed amendment.
Thank you, Madam Chair. I propose an amendment to Clause 2 of Schedule 5 to delete the words "and accompanying documents," so that the clause now reads, Madam Speaker, the recording secretary of the committee shall circulate the agenda and accompanying documents for the meeting to members 5 working days prior to the meeting. And I want to delete an accompanying document so that the new clause would read, the recording secretary of the committee shall circulate the agenda for the meeting to members 5 working days prior to the meeting. because, Madam Speaker, if the government is concerned about the mafia and the collusion and the bidding rings and stuff, I don't think you want the documents that they're going to consider to be out there circulating 5 days prior to the meeting.
Mr. Miller, could you be so kind as to repeat what you just said, because it didn't seem to follow what I had in my hand?
In subclause 2, Madam Speaker, delete the words and accompanying documents.
Yes.
So it would then read, the recording secretary of the committee shall circulate the agenda for the meeting to members 5 days prior to the meeting. Right.
And it has subclause 10?
But you want to do both at the same time? In subclause 10, by deleting as soon as may be practicable, the minutes shall be considered a public document and posted on the Public Procurement Committee website. And substituting the following new clause, all meetings of the committee shall be held in public and the minutes shall be posted to the Public Procurement Committee website within 24 hours of the meeting concluding.
The amendment has been duly moved. Does the member wish to speak further to the amendments?
Only to say, Madam Speaker, that again, it is not intended here that the public would be allowed to participate in the meeting, but they could witness and see and hear what went on in the meeting.
If no other member wishes to speak to the proposed amendment, the question is that the amendment to the Schedule Sun part of the bill, the Schedule 5, all those in favor, please say aye. Aye. Those against, no.
No.
I believe the noes have it. Accordingly, the proposed amendment does not pass.
Schedule 6, roles and functions.
Madam Chair, I think the government submitted amendments to Schedule 5. And the vote just now was on Mr. Miller's proposed amendments.
Thank you, Honourable Minister. You're absolutely correct. I recognize Honourable Minister for your proposal to Schedule 5.
Thank you, Madam Chair. Madam Chair, I propose that Schedule 5 be amended by deleting paragraphs 10 and 11 and substituting the following paragraphs. Paragraph 10, within 30 days of the meeting, the minutes shall be posted on the Public Procurement Committee's website. To the extent that any information is exempted in law, the minutes shall be presented with the relevant information in a redacted form.
The amendment has been duly moved. Does any other member wish to speak to the government's amendment? If not, the question is that the amendment to Schedule 5 stand part of the clause. All those in favor, please say aye.
Aye.
Against, no. I believe the ayes have it.
Madam Chair, excuse me, ma'am. I
Sorry.
think there may be a further amendment in
Paragraph 11.
paragraph 11 on Schedule 5. Turn the page over.
Honourable Minister.
Paragraph 11, the committee shall provide the chief officer of the Ministry of Finance with an unredacted copy of the minutes upon the confirmation of the minutes. Thank you, Madam Chair.
The amendment has been moved in full. So out of abundance of caution, I'll just put the amendment in one piece again. Thanks, second elected member. The question is that amendment to clause 5 stands part of the clause. All those in favor, please say aye.
Aye.
Those against, no. The amendment to clause 5 now stand part of the clause. Schedule 5, I beg your pardon, stand part of the clause. The question is that clause 5 as amended stand part of the bill. All those in favor, please say aye.
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 Against, no. I believe the ayes have it. Schedule 5 as amended now stand part of the bill.
Schedule 6, roles and functions.
Recognize the member from Northside.
Thank you, Madam Chair. Again, I propose to delete the current definition for the role of cabinet and substitute the role of cabinet is to make regulations in accordance with this law.
The amendment has been moved. Does a member or any other member wish to speak to it? If not, the question is the schedule. One minute. Honorable member from Northside,
I have two other ones, but
That's-
for the role, that one relates to the role of cabinet under the law. This one relates to the role of the chief executive officer. And where it says the executive officer is responsible for delivering outputs and overall outcomes and have been established by the cabinet, the and substitute the word to the board of the respective entity.
so do you wish the chair to put them collectively or individually?
They're voting it down so you can go anywhere you want, Marcia.
I think that's equal to a request to put it together.
Yeah, you can put all three of them together.
Can you do number 3 then?
Again, under the role of entity procurement committee in subclause 2, to add a new section N to read, all decisions of the entity procurement committee shall comply with Schedule 1.
The 3 proposed bills have been moved. If no other member wish to speak, the question is that the proposed amendment to Schedule 6 stand part of the clause. All those in favor, please say aye.
Aye.
Against, no.
No.
I believe the noes have it. The amendment is not carried. The question is that Schedule 6, the government has an amendment?
Yes, Madam Chair, my apologies. Madam Chair, I propose to amend Schedule 6 in paragraph H. Paragraph H, the role of the chief officer in a given ministry or portfolio, that we delete the words existing document and substitute the words existing records. And in paragraph H of the role of the chief officer, delete the words existing document and substitute the words existing records.
The amendment has been duly moved. Does any other member or the mover wish to add anything further to it?
Madam Chair, that's nothing to add, Madam Chair.
The question is that Clause 6 as amended stand part of the clause. All those in favor, please say aye.
Aye.
Those against, no. The ayes have it. The amendment now stands part of the clause. The question is that Schedule 6 as amended stand part of the bill. All those in favor, please say aye.
Aye.
Against, no. The ayes have it. Schedule 6 now stands part of the bill.
New clause 7.
Schedule 7.
Sorry. New schedule 7.
Recognize the member from Northside.
Madam Chair, I wish to introduce a new schedule to read. The bill to be amended to add a new Schedule 7 to read. 1, all procurement less than 50,000 to be done by the Entity Procurement Committee by obtaining 3 bids. 2, all procurement above 50,000 but less than 250,000 to be done by the Entity Procurement Committee in compliance with this law. And 3, all procurement above $250,000 to be done by the Public Procurement Committee in compliance with this law.
The amendment has been duly moved. Does any member or the mover wish to speak further to this amendment? The question is that the amendment by the addition of a new Schedule 7 stand part of the clause. All those in favor, please say aye. Aye. Those against, no.
No.
I believe the noes have it.
Can we have a division?
Madam Clerk, please call a division.
People out there voting yes, and then you count them as no.
There's no way in the law that sets that scheme up, unless you rely on the
What are you doing?
the public finance law to set it.
Honorable Alden McLaughlin. No. Honorable Moses Kirkconnell.
No.
Honorable Kurt Tibbetts.
No.
Honorable Osmond Barton.
No.
Honorable Wayne Panton.
No.
Honorable Marco Archer.
No.
Honorable Tara Rivers.
No.
Mr. Roy McTaggart.
No.
Mr. Joseph Hugh.
No.
Honorable McKeeva Bush.
Aye.
Mr. Barney Bush. Captain Eugene Ebanks.
Aye.
Mr. Alva Saku.
Aye.
Mr. Winston Conley.
Aye.
Mr. Ezra Miller.
Aye.
Mr. Arden McLean.
Aye.
Honorable Anthony Eden.
Mine.
The results of the division are as follows: 6 ayes, 9 noes, 2 absentees. The amendment has failed.
A bill for a law to provide the framework for the procurement of goods and services by the Cayman Islands government, to establish the central procurement office, and for incidental and connected purposes.
The question is that the title stand part of the bill. All those in favor, please say aye.
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 Against, no. The ayes have it. The title now stand part of the bill.
The Dangerous Substances Handling and Storage Amendment Bill, 2016. Clause 1, short titling commencement. Clause 2, amendment of the Dangerous Substances Handling and Storage Law, 2003. Clause 3, amendment of Section 2, interpretation. Clause 4, repeal of Section 5, the Dangerous Substances Handling and Storage Board established. Clause 5, repeal of Section 7 and substitution, meetings of the board. Clause 6, repeal of Section 8, duty of confidentiality. Clause 7, repeal of Section 9, remuneration of the board. Clause 8, amendment of Section 9A, fuel standards committee. Clause 9, amendment of Schedule 9B, functions of the committee. Clause 10, amendment of Schedule 9C, procedures at meetings, etc. of the committee. Clause 11, amendment Schedule 10, Chief Petroleum Inspector. Clause 11, amendment of Section 11, identification cards of inspectors. Clause 13, amendment of Schedule 15, general duties and powers of the Chief Petroleum Inspector. Clause 14, transitional provisions, transfer of public officers to the office.
The question is that clauses 1 through 14 stand part of the bill. All those in favor, please say aye.
Aye.
Those against, no. The ayes have it. Clauses 1 through 14 now stand part of the bill.
A bill for a law to amend the Dangerous Substances Handling and Storage Law 2003 and for incidental and connected purposes.
The question is that the title do stand part of the bill. All those in favor, please say aye.
Aye.
Against, no. The ayes have it. The title now stand part of the bill.
ICT. I know. The Electricity Regulatory Authority Amendment Bill 2016, Clause 1, short titling commencement. Clause 2, amendment of Section 1 of the Electricity Regulatory Authority Law 2010 revision, short title. Clause 3, amendment of Section 2, definitions. Clause 4, amendment of Part 2, establishment, capital, and administration of authority. Clause 5, amendment of Section 9, functions of authority. Clause 6, repeal of Section 24, shares of licensee, etc., not to be issued or transferred without approval of authority.
The question is that clause 1 through 6 stand part of the bill. All those in favor, please say aye.
Aye.
Against, no. The ayes have it. Clauses 1 through 6 now stand part of the bill.
Clause 7, repeal of Parts 5, 6, and 7, anti-competition practices, cease and desist orders, administrative fines.
Honourable Minister for Works, there's an amendment.
Thank you, Madam Chair. Madam Chair, in accordance with the provisions of the relevant standing orders, I move the following amendments to the Electricity Regulatory Authority Amendment Bill 2016. That the bill be amended by deleting Clause 7 and substituting the following clause. Madam Chair, in the marginal notes, open quotation, repeal of Parts 4, 5, 6, and 7 Roman numerals, directives by authority, semicolon, anti-competitive practices, semicolon, cease and desist orders, semicolon, administrative fines. 7, the principal law is amended by repealing Parts 4, 5, 6, and 7. And Madam Chair, just so that it is very clear to everyone, the only difference in this and what was originally in the bill is that Part 4 is added to the new amendment.
The amendment has been duly moved and spoken to. The question is that the amendment stand part of the clause. All those in favor, please say aye.
Aye.
Those against, no. The ayes have it. The amendment now stands part of the clause. That's Clause 7 as amended. The question is now that Clause 7 as amended stand part of the bill. All those in favor, please say aye.
Aye.
Against, no. The ayes have it. Clause 7 as amended now stand part of the bill.
Clause 8, amendment of Section 68, equipment standards and technician certification. Clause 9, repeal of Part 10, reconsideration of decisions and appeals. Clause 10, repeal of Section 78 and 79, refusal to produce documents, etc., given false information. Clause 11, repeal of Section 83 to 86, offenses by bodies corporate, offenses under Part 5, destroying or falsifying documents, false or misleading information. Clause 12, amendment of Section 89, power to make regulations. Clause 13, repeal of Section 90, immunity and indemnity. Clause 14, insertion of Part 13, dissolution of authority. Clause 15, repeal and substitution of Section 93, transitional provisions. Clause 16, insertion of Section 94, interpretation for the purposes of Part 13. Clause 17, repeal of first schedule, procedure of board. Clause 18, amendment of miscellaneous provisions, substitution of the word office for the word authority. Clause 19, amendment of miscellaneous provisions, substitution of the word cabinet for the word governor.
The question is that clauses 8 through 19 stand part of the bill. All those in favor, please say aye.
Aye.
Against, no. The ayes have it. Clauses 8 through 19 now stand part of the bill.
A bill for a law to amend the Electricity Regulatory Authority Law 2010 revision as a consequence of the establishment of the Utility Regulation and Competition Office to dissolve the Electricity Regulatory Authority and transfer its powers and responsibilities to the Utility Regulatory and Competition Office and to make provision for related matters.
The question is that the title now stand part of the bill. All those in favor, please say aye.
Aye.
Against, no. The ayes have it. The title now stand part of the bill.
The Information and Communications Technology Authority Amendment Number 2 Bill 2016. Clause 1, short title and commencement. Clause 2, amendment of Section 1 of the Information and Communications Technology Authority Law 2016 revision, short title and commencement. Clause 3, amendment of Section 2, definitions. Clause 4, amendment of Part 2, establishment, capital, and administration of authority. Clause 5, amendment of Section 9, powers and functions of authority. Clause 6, amendment of Section 25, shares of licensee not to be issued or transferred without approval of the authority. Amendment of Section 9, powers and functions of the authority. Clause 7, insertion of Section 25A, media enterprises. Clause 8, amendment of Section 28, duration of license. Clause 9, amendment of Section 31, modification of license. Clause 10, repeal of Part 4, competitive practices. Clause 11, repeal and substitution of Part 5, cease and desist orders. Clause 12, repeal of Part 6, administrative fines. Clause 13, amendment to Section 65, interconnection. Clause 14, amendment of Section 66, interconnection agreements. Clause 15, amendment of Section 67, pre-contract disputes.
The question is that clauses 1 through 15 stand part of the bill. All those in favor, please say aye.
Aye.
Against, no. The ayes have it. Clauses 1 through 15 stand part of the bill.
Clause 16, insertion of Section 67A, power of the office to consider disputes on its own initiative. Clause 17, amendment of section 68, cost of interconnection. Clause 18, amendment of section 69, infrastructure sharing. Clause 19, amendment of section 72, quality of service. Clause 20, amendment of section 74, equipment standards and technician certification. Clause 21, repeal of Part 9, review of administrative decisions and appeals. Clause 22, repeal of section 85 to 87, refusal to produce documents, etc., giving false information, failure to attend to give evidence. Clause 23, repeal of section 91, offenses by bodies corporate. Clause 24, amendment of section 97, power to make regulations. Clause 25, repeal of section 98, immunity. Clause 26, insertion of Part 12, dissolution of authority. Clause 27, amendment of section 101, transitional arrangements. Clause 28, insertion of section 102, interpretation for the purpose of Part 12. Clause 29, repeal of Schedule 1, procedure of the board. Clause 30, amendment of miscellaneous provisions.
The question,
Substitution of the word office for the word authority.
the question is that clause 16 through 30 stand part of the bill? All those in favor, please say aye.
Aye.
Against, no. The ayes have it. Clauses 16 through 30 now stand part of the bill.
A bill for a law to amend the Information and Communications Technology Authority Law 2016 revision as a consequence of the establishment of the Utility Regulations and Competition Office to dissolve the Information and Communication Technology Authority and transfer its powers and responsibilities to the Utility Regulations and Competition Office and to make provisions for related matters.
The question is that the title now stand part of the bill. All those in favor, please say aye.
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 Those against, no. The ayes have it. The title now stand part of the bill. We're going to take the afternoon break at this time.